I mean, the big case, the white pill of white pills, is the Fifth Circuit Court of Appeals decision that said Texas law prohibiting social media companies from engaging in censorship when they reach monopoly power of the public digital square is absolutely and completely constitutional. And it will likely get up to the U.S. Supreme Court. It already briefly was before. So we'll get into previewing what that is. But the decision is a fantastic decision, such a good decision that I'll not only be posting a highlighted version of it at vivabarneslaw.locals.com, but we'll be doing a podcast on the decision recorded for our members there. So that's the big one. There's Trump special master news. Mike Lindell is entangled with the FBI. That's apparently just wandering around wanting to investigate and indict anybody they can that's connected to a Trump supporter on whatever grounds possible or plausible. There's a range of other cases, including the what's going to happen with federal digital currency, the efforts by the Treasury Department to not only unleash the IRS on everybody, but to go after Tornado and other other means by which people engage in cryptocurrency and issues as to whether or not that's speech or not. And several other cases, including a fun one, which is when a federal judge says it's okay to call a meat a veggie because the word veggie is so ambiguous that it apparently includes meat, according to the federal judge.
We'll get to that. We'll get to that one because that was my question. I didn't see that there was actual meat in it. I just thought that it was not enough vegetables to qualify it as a veggie. Do we want to start with the Texas decision?
Yeah.
Okay. So, I mean, this was in the news a while back. I mean, there were two stages of this decision because a while back they said you can't, the law can be enforced, but they didn't give a good reason. And now they've given a good reason for which social media companies, even though they're private enterprises, cannot censor based on viewpoint discrimination. Robert, well, I guess one question we're going to get to is this going to just be ignored? Is it going to be applied only in one state? But flesh out the decision. Let us know why it makes so much sense, even though a lot of us have been saying this is the way it should be for a long time.
Yeah, I swear I didn't write the opinion, but it basically represents my own thoughts on this topic going on about a half decade. And it's really striking when you see that when some of us first set out discussing this and laying out the legal roadmap as to why big tech was in the wrong, why there was a legal right to control their conduct, we were in a small minority because big tech had bought off a lot of the legal academy. So a lot of your, David Frenchie types that are supposedly on the right, a range of people that are supposedly on the libertarian side were embracing big tech censorship under the guise that they had an absolute right to do so, that somehow censorship was speech, despite the way Section 230 was written itself to say that censorship could never be speech. So in that sense, it was striking. It's really a remarkable ruling across the board. So Texas and Florida and other states are considering it. But Texas law is really a pretty good roadmap. It's what some of us have recommended the changes to Section 230 should reflect on a federal level that would elude some of these constitutional questions that the big tech companies are even trying to raise in the first place. But putting that aside, what Texas did is they said, if you have more than 50 million users in the public digital square, if you will, then the net effect of that is you can no longer engage in viewpoint discrimination. You also have to maintain data about when you do engage in it. That data has to be available to the Texas Attorney General. They can bring action if you're not being transparent, either to consumers or users or the state about what you're up to. But fundamentally said you just can't censor. And what they meant by censor was very broad. Not just deplatform someone, not just remove their access to it, but also anything that reduces their visibility. In fact, explicitly included is demonetization, for example. So this is something that could effectively financially reverse the equation for all of big tech. If big tech continued to engage in viewpoint-based discrimination, it could be sued. Now, there was no damages imposed on it. The only requirement is that they would have to reinstate the person with a court injunction with declaratory relief, and they would have to pay the attorney's fees and cost of bringing the case. So I'm licensed. I'm a general member of the Western District of Texas, for example. So I can tell you I'm looking at bringing suits soon. What they did is the big tech companies got together, and as soon as the law was passed and before it could even be enforced, brought suit in a federal district court that just went along with every single claim that big tech made and said there's no way this statute could ever be constitutional. The primary predicate of that, there was a range of secondary and subsidiary issues, but the primary basis is a claim big tech has long made, which is that they have a right to censor as their right of freedom of speech and freedom of expression and freedom of association. Now, some of us, David Frenchy types would advance this position. A range of so-called conservatives on the right would advance this position, as well as a lot of libertarian so-called legal people would advance this position. And I think Dave Smith at times is unaware of what some of his libertarian comrades are up to. God bless him. Because he was recently being very critical of Alex Jones and some other people for Alex Jones's criticism of certain libertarian positions. But it's because a lot of libertarian positions have been corporatist positions, not really constitutional positions.
Well,
not all, but there's plenty of exceptions to that, but far from the dominant sentiment, quite frankly, at least in our experience. But maybe we'll debate that with Dave Smith if he is able to come on at some point in the future. But so that was their core position, is that you could never control what they do at the state level or at any level, because they have a constitutional right to censor, a constitutional right to manipulate the algorithm, a constitutional right to editorialize without even people's notice or knowledge that that's what they're doing, a constitutional right to deplatform, demonetize, you name it.
And just to flesh out the argument for people who might only be hearing it for the first time. And side note, Robert, I got in trouble with the Libertarian Twitter account because I said I don't like tweets where they wish death on people or revel in the death of people. But I said I don't know who they're trying to appeal to with that type of Twittery. But the argument of freedom of speech is that these companies are private corporations and they too can exercise freedom of speech, which is to prohibit or block certain speech on their platforms. The full argument to that is it's not a question of them applying rules that are terms of service uniformly or consistently. They're just outright politically selectively prohibiting certain types of speech based on viewpoint. And they say, well, we can do that anyhow, because even though we're a private corporation, we still have First Amendment rights to block the speech that we want to block. And we get to protect that conduct under First Amendment rights. That's accurate enough?
Yeah. That's been their argument. And a lot of so-called legal scholars have bought this argument. The problem with it, as the Fifth Circuit details, it takes apart all the legal basis for the claims, the historical problems with the claims, and the analogous problems with the claims. The court also takes some nice pot shots, because they kept saying, you want us to force Nazis and terrorists on here, and we don't want Nazis and terrorists on here. By the way, they've had no problem promoting terrorism. So that was kind of an ironic point. Twitter, has been unsuccessfully sued for its promotion and propagation of a range of terror groups all around the globe, of being a key medium of communication and incitement all around the globe. So, and by the way, this Texas law, basically, if you read the law reads exactly like the rules we wrote for Rumble. So it carves out direct incitement, unlawful conduct, pornography, stalking, harassment. Any conduct that's already illegal is not allowed. And they can completely and freely censor any illegal conduct. What they can't do is discriminate based on viewpoint. That's all they're doing. That's all that it limits too. It doesn't limit anything else. And so what their challenge was is they felt they had a First Amendment right. The problem is there's no basis for that. There is no court case, as the Fifth Circuit noted, no court case anywhere ever in American law that has said the First Amendment includes a right to censor. It doesn't exist. The right to speech is not a right to censor. In fact, as they point, the cases they cite are cases where someone is forced to either give a certain speech or forced to associate with other speech. The problem for big tech is because of their successful lobbying in the Section 230 context, it's already been determined as a matter of federal law that hosting other people's speech is not your speech nor associated with your speech. So they couldn't make that claim. And what the Fifth Circuit pointed out is that if they were right, that there's an absolute right to censor, then all of a sudden email companies could censor, telephone companies could censor, banks could censor, utilities could censor. And their point is, we've always rejected that. Indeed, this was brought up in a different part of the Pruneyard case that I talk a lot about. In Pruneyard, the California Supreme Court said that malls are functioning as a monopoly on the public square, and consequently, they cannot, even though it's a private mall, cannot discriminate against people. What content-based discrimination, viewpoint-based discrimination, based on what speech people engage in, like petitioning and other activities in the public part of the mall, even though that's all owned by the company. And they took that up to the U.S. Supreme Court, and they said, U.S. Supreme Court, they're forcing speech on us. They're forcing us to associate with speech. U.S. Supreme Court said, no, that's not forcing you to associate with speech. That no one's going to confuse someone walking around the mall handing out a petition or anything else or pamphlet or talking about something with the mall, with that being the mall speech. And they pointed out these other cases, PG&E and a range of other cases, Miami Times, were all cases where the private company was being penalized or punished based on the content of their speech. Either they were forced to speak in a certain way, forced to host or associate with speech in a certain way that would be associated with them. This is why certain parades, for example, can't exclude people legally, because the parade, anybody in the parade would be associated with the sponsors of the parade. That is not the case with big tech as a matter of federal law for over 30 years. So their point was the big tech's censorship, that's conduct. That's not speech. And it's nobody's going to confuse, and nobody's limited. The law doesn't limit Twitter from saying whatever it wants in response to somebody's speech, from sticking some sort of label on it. Doesn't prohibit that either, as long as it's not defamatory or libelous. And they made that point as well. They said all it does is you hosting speech. You're not allowed to, in the way you host speech, censor people based on viewpoint, especially as they pointed out, when all of this public monopoly that has been achieved and attained by these companies was attained and achieved by their promise of protecting and promoting free speech. So they recognized the real problems that exist. They looked at the full First Amendment history. And the biggest, most important part of their ruling is that the right to censor does not exist. It's not a constitutional right. Just not there, period. They said even if it is there, it would be because it's content neutral law. It just requires no viewpoint discrimination. It doesn't differentiate between viewpoints. Then consequently, it would apply to a lower level of scrutiny, such that even if it had First Amendment protection, which it frankly doesn't, it doesn't rise to the level of core political speech that has the zenith of First Amendment protection, and it's not applicable. And here, the nature of these rules are fine anyway, even if you could call censorship with the speech with a right to censor. Bottom line, free speech does not include a right to censor. It includes a right not to associate with whom you want. But when you're a platform, you're not associating with anybody, and that's been proven law for 30 years.
Did the decision address Section 230 as to how they can remain compliant with Section 230 while also not engaging in viewpoint discrimination?
Well, because the Texas law did. So the Texas law said they can censor anywhere federal law authorizes. They can censor anywhere there's direct incitement. Basically, our Rumble rules.
Yep.
So anywhere there's illegal conduct, they're completely free to censor. And so that's always been the case. But they're not allowed to censor based on viewpoint alone. It must be, this is direct incitement, this is stalking, this is harassment, this is pornography, this is something that's already illegal. And if it's not already illegal, can't ban it, can't prohibit it, can't censor it. And you have to keep a record of everyone you do censor. It also required they incorporate a comment, a right to appeal, a due process component before they take adverse action based on any kind of viewpoint activity or other activity. And so this was a simple, clean, neat law, directly conformed to the law. Now, what happened initially is went up to the federal district court judge. The federal district court judge said, "Oh, I hate this law. I'm going to stop it altogether." Went up to the Fifth Circuit. The Fifth Circuit said, "We don't think this law has the problems you're identifying. We vacate your injunction." That went up to the U.S. Supreme Court. The U.S. Supreme Court reversed the Fifth Circuit on the stay issue. It has not ruled on the merits as yet. What was interesting was the vote breakdown. 4 justices said they agreed with the Fifth Circuit and for vacating the stay. 5 said they thought the stay should stay in place until the Fifth Circuit makes a ruling. Fifth Circuit now has. The 4 justices, though, were interesting. They were the 3 core constitutional conservatives, Thomas, Alito, and Gorsuch. The 4th was Justice Kagan. So Justice Kagan dissented from her liberal colleagues and thought the law was just fine, wrote a very strong dissent, suggesting there's problems with big tech control and monopoly in this space. She has an occasional free speech streak, and it came through strong. That means they only need one of the 3 other Republican-appointed justices on the bench. So who are the 3 Republican justices that failed to step up at the initial stage? Unsurprisingly, Justice Roberts. Also unsurprisingly, as he did again this week, Justice Kavanaugh. Conservatives should ask, well, all that fighting they did to get that guy on the bench. Kennedy recommended him for a reason, folks. And it's not because he's a constitutional conservative. He will be sporadically good on certain issues of religion, certain issues of the regulatory reach of the state, certain issues on guns. He will be mostly useless on a lot of other issues. And of course, the last justice who failed to step up to the plate, Justice Amy Coney Barrett. As some of us said, outside of the business context, outside of religion, outside of guns, like Kavanaugh, she's an unreliable vote. So the undependable, as she was as the deciding vote that led to the election challenge never being heard at any level before or after the election by the U.S. Supreme Court. Now, all they need is one of those 3 to join the other 4. This is an exceptionally well thought out decision by the Fifth Circuit. They can't challenge, and they already have 4 basically justices they know that are with them. So they just need either Roberts or even maybe the new justice, who knows where she's going to go, the new liberal justice, or Barrett or Kavanaugh to recognize the wisdom of the Fifth Circuit's logic that this law is clearly a constitutionally permitted law, that the right to censor has never existed, that if they say it does exist, all of a sudden you could lose your email accounts, your phone, your mobile phone service, a wide range of basic public utilities, your banking access tomorrow.
Payment processing, your ability to exist in a civil society. But Robert, now playing devil's advocate just a tad, the 5 justices who opposed the stay pending the appeal, they could come around on the merits and say, look, we were opposing the stay on procedural grounds, but on the merits, we've now seen the light, or we never didn't see the light in the first place. We were just being stickless for procedure. It's going to get up to the Supreme Court. I mean, they're going to appeal.
Oh yeah, high likelihood is my guess.
In the interim, though, what is going to be the practical impact? Does this only has impact in Texas? Is there a chance that the social media companies or whoever the big tech companies are that this applies to simply say, all right, we're not going to do business in Texas?
Well, yeah, that's not going to happen.
I don't even know how conceptually how that can be done. But
I mean, also Florida has a similar law that's also going up through the process. This Fifth Circuit decision will likely influence the 11th Circuit decision. So, and there's more states considering this law. And now that Fifth Circuit has affirmed it, you'll see even more states push it through. So you'll probably have about half the country. So does Twitter not want to exist in half the country? Does YouTube want to not exist in half the country? Does Facebook want to not exist in half the country? That's not an option for them. So their only real option is to risk lots of lawsuits in which they write lots of checks to lawyers for the other side and basically fund their legal opposition, or go along and stop doing politically based censorship. From a financial perspective, the easy thing for them to do, the practical thing for them to do, is to quit doing viewpoint discrimination and incorporate these rules. Basically look at Rumble's rules, replicate them for themselves. It just goes against the political prejudice of a lot of its engineers, a lot of its high-ranking executives, and some of its key investors, and people like George Soros and others that have tried to influence and shape their direction. So that's the tug and pull that's taking place. But practically speaking, the logical decision is not to get sued by everybody in Texas every time you try to do anything to their accounts. And so it's also not clear that from my review of it, I don't think you have to be a Texas resident to bring suit. I'm still researching that question, but from my initial review of it, anybody could sue in Texas under the Texas law. So potentially, because their voice is being limited in Texas. There's jurisdiction in Texas. Whenever your account is demonetized, they're preventing people in Texas from seeing and hearing your view. They're limiting visibility to people in Texas. That's why, as a practical matter, unless they decided to make themselves inaccessible to the whole state of Texas, they're either going to face a long litany of lawsuits that are coming, or they're going to change their behavior and conduct going forward. Now, the court left open an as-applied challenge. This was a facial challenge. So it suggested that under certain circumstances, there might be some unique set of circumstances where the law isn't constitutional as applied. But given the breadth of its decision, it's quite clear that you could file suit in federal court in Texas, and 95% of the people that have been deplatformed, censored, demonetized, discriminated against, etc., can sue and get their lawyers get reinstated, which would be their goal, and have their lawyers' fees paid by the other side. They're basically making them pay for their legal adversaries if they continue to discriminate.
Let me ask you the obvious question. Is this retroactive, or is this only going forward? So those who have already been deplatformed prior to this law existing are still going to be without recourse?
Correct.
Okay. So that'll answer the question for Alex Jones and others. I was just thinking Texas residents. So only going forward, prospective, not retrospective, and tough noogies for everybody else who's been screwed prior to this law, but a step going forward. Very interesting. I mean, it's almost like they're just going to have to find legal justification now, or lawful explanations for.
They have to limit their rules to what Rumble's rules are. They've got to limit it to unlawful conduct if you didn't engage, and they've got to give you a meaningful due process if they claim that you did something unlawful. So they got to do both, and they're doing neither right now. Rumble's rules incorporate both. That you have to do something unlawful, or you can continue to communicate on Rumble. And if Rumble thinks you did something unlawful, Rumble affords you a complete, robust, multiple levels of due process rights. This law requires less than what Rumble requires, but still requires more than what anybody like YouTube or Twitter or Facebook is giving. And that's, Google and Instagram and all the rest are ultimately equally applied to it. The other thing is, to me, they can use this as a predicate to expand new legislation into other areas. Prohibit banks from engaging in political viewpoint discrimination. Prohibit email providers from engaging in political viewpoint discrimination. Prohibit telecommunications companies from engaging in political viewpoint discrimination. Because this has been happening on a massive scale. Prohibit internet service providers from engaging in viewpoint discrimination. They're trying to politically weaponize everything. I have a client, have a deposition tomorrow, in fact, in his case, who was a longstanding good customer of a major U.S. bank. And the U.S. bank decided to undermine his position financially purely for political reasons, to the tune of tens of millions of dollars. Often the bank in the process losing money itself. That's what some of these banks have been doing. They've been costing themselves money just to politically weaponize their access. We saw another version of that with Visa and the credit card companies, saying that they're going to start creating a separate merchant code for gun sellers so that they can track and trace every single gun company, gun seller, gun purchaser in America. So there's that. That's the surveillance aspect of this. So the removing the ability of companies to discriminate on viewpoint bases when they are the sole source of access in many cases, or the primary monopoly level source of access, is critical in a wide range of areas. And this law made clear there is no right to censor. Your right to free speech is not a right to censor. Doesn't exist. Now, it doesn't. If it's truly association, then it's forced speech. So, for example, somebody said, well, could this force, if you apply this law in broader context, could it force me as an employer to have people wearing political T-shirts I disagree with? No, it wouldn't, because that would likely be seen as your speech. That's the difference. On the other hand, if let's say you are an event venue and you let anybody come and speak at that event venue you want, nobody's going to confuse the Milwaukee Bradley Center with promoting the Republican Party simply because it hosts the Republican National Convention. So, that's always been kind of nonsense to me. And that's the point. And that's where all of these so-called legal scholars said it was so obvious that the First Amendment prohibits these laws. We're always full of crap, because they couldn't make an obvious distinction. Now, some of this is because of the corruption of the legal academy. If you see people writing tech law newsletters and tech law blogs, I don't know, maybe like Tech Dirt, people like this, they're frauds. What do I mean they're frauds? They purport to be independent, objective analysts who are functionally and fundamentally and often literally in the pockets of big tech. This is true for many law professors that are in the big tech legal space. You dig in, and when I dug in early, I discovered how almost all of them were compromised or conflicted. They're like doctors associated with the FDA and with big pharma. You dig in, and it doesn't take long to figure out follow the science just means follow the money. And so the same is true here. But this is a massive decision, a brilliantly crafted decision, in my view, of impeccable logic and reason and historical evidence. And so the U.S. Supreme Court will be under a lot of pressure to try to resist or refuse or reject this. And if we win on this, then it opens the floodgates to legal and legislative remedies to finally stop big tech censorship in America.